迎各位出席今日嘅簡報會啦。咁疫情嘅關係，咁各位咧就請保持社交距離。咁因應今日嘅特別安排咧，各位係可以喺簡報會嘅期間喺呢個法庭大堂嗰度錄音、影相、錄影同埋直播嘅。終審法院首席法官張舉能咧會先同大家講幾句，然之後先再接受大家嘅提問。唔該，張官。
好。嗱，各位大家好啦嚇，多謝大家出席今日嘅傳媒簡報會啦。我就會咧用中文咧就簡單嘅複述一下我正話喺法律年度開啓典禮嘅講詞啦，然後咧我就會答大家嘅問題嘅。咁喺我用中文簡介之前咧，我或者用幾句英文咧就解俾我哋英文嘅同事聽，等佢哋咧明白發生咩事，然後咧就我就會用中文嚟簡介㗎啦。Now, welcome everybody to this media session. What I propose to do is to give a brief summary in Chinese of what I've said just now at the opening of the legal year, as this is going to be a summary only in Chinese for the benefit of our friends in the public media. I do not propose to repeat my summary in English because it is merely a summary of what I've said in English just now at the opening of the legal year. After giving the summary in Chinese, I will take questions from the floor. Now I'll switch back to Chinese. 嗱，各位大家好啦嚇，我喺去年就任終審法院首席法官，帶領司法機構咧經歷過去非常重要嘅一年。亦都有挑戰嘅。今年我哋面對嘅事情咧都唔少。我而家咧喺呢度咧同大家咧簡單嘅介紹一下。香港係法治社會，法治確保並促進咧公平、平等同埋公義，呢啲都係我哋法律制度之下執行司法工作嘅核心價值。香港法治係一大關鍵咧，就係獨立嘅司法機構。獨立嘅司法機構咧，對香港喺一國兩制之下繼續嘅成功咧，非常重要。根據基本法咧，香港享有獨立嘅司法權同埋終審權。法院嘅獨立進行審判咧，不受任何干預嘅。基本法同埋有關嘅法例咧，對法官嘅任免咧都有清晰同埋嚴格嘅規定。司法機構透過公開嘅聆訊啦、公開嘅宣佈同埋公開嘅判決咧，就係落實受憲制保障嘅司法獨立。嗱，根據香港區國安法第44條嘅規定，涉及危害國家安全罪行嘅案件咧，只可由行政長官根據該條文所指定嘅法官審理。喺處理有關嘅案件時候咧，法庭係會公正持平，絕唔會因為咧該條文嘅特別安排咧有所影響嘅。指定法官嘅所有指定法官咧都係現任法官嚟嘅。既然係現任法官咧，就必先係已經符合咗基本法第92條就選用法官嘅司法同埋專業才能方面嘅嚴格要求咧，滿足咗，並且咧必須係恪守咧司法誓言，在作出司法決定嘅過程之中咧，唔容許有任何嘅政治或者佢個人嘅因素考慮咧參與在內嘅。佢嘅做法去審案咧，同其他嘅類別嘅案件咧完全一樣，而且咧委派邊一個指定嘅法官去審理邊一單案件咧，個責任同埋權利咧都喺返相關法院領導嘅職責裏邊嘅。我哋歡迎有益同埋有建設性嘅批評，但係缺乏客觀事實或出於政治考慮嘅評論呢，就毫無意義啦。試圖威嚇法官嘅行為呢，更必須予以譴責。法官一如以往呢，堅定不移秉行公義， 為確保司法工作咧得以妥善執行，我哋亦都加強咗法院大樓嘅保安措施。去年8月16號開始呢，就針對法官同埋司法人員行為投訴嘅兩層架構咧，處理機構咧架構咧已經生效啦。性質嚴重嘅咧，可跟進嘅投訴咧會先由法官小組調查，諮詢委員會，然後再審視，再由咧我作為首席法官咧作最終嘅決定嘅。呢個機制咧提高制度嘅透明性同埋問責性，以及咧市民咧對司法機構嘅信心。我哋正更新咧法官行為指引，指引咧由2004年推出以嚟咧，司法行為嘅議題咧已有不少演進同埋發展啦。我已經接納咗由高等法院首席法官領導嘅工作小組嘅報告，新一版嘅指引咧快將製備咧完成。司法機構一如既往採取不同嘅措施，提升司法效率。除了繼續招聘司法人員、擴展司法助理嘅計劃，法庭施加嚴格嘅案件管理指引，亦會咧就法官喺押後宣判時即場訂定頒下判決嘅日期同埋時間框架咧，作出新嘅實務指引。另外咧，我哋會正係增建緊新嘅法庭，同埋增加現有法庭嘅運作效益，以應付咧涉及眾多訴訟方同埋律師嘅刑事案件審訊嘅，有助加快審理案件。至於電子法方面呢，我哋會分階段開發一個涵括各級法院嘅綜合法院案件管理系統，亦正着手咧處理法例嘅修訂工作，讓喺合適嘅情況下咧，以遙距嘅方式進行聆訊。呢方喺民事同埋刑事方面咧都係一樣嘅。係啦，嗱，我嘅總結呢，或者簡介咧就係咁多啦。而家咧我就開始接受大家嘅問題。I'll take questions from the floor now。
好，而家係答問嘅環節。咁提問嘅記者請先舉手啦，用大會提供嘅咪發問。咁先講出代表嘅傳媒機構。咁每個人最多問3條。前面呢位女記者，粉紅色衫呢個。
你好，係《星島日報》記者嘅。咁係想問翻張官呢，近年呢，有一啲示威案審訊嘅時候呢，有一啲旁聽師喺度叫囂拍手，又或者有人呢會戴一啲政治色彩嘅口罩入庭啦。咁呢啲行為其實係咪構成藐視法庭呢？同埋有唔同嘅法官呢，有唔同嘅做法啦。有一啲會趕佢哋出庭啦，有一啲就唔會理會佢哋啦。咁張官對於呢啲行為有咩睇法呢？覺得應唔應該俾佢哋入庭旁聽呢？同埋司法機構呢，會唔會提供一啲統一嘅指引俾法官同埋司法人員去處理呢啲事呢？
嗱，多謝呢位幾位記者朋友嘅問題啦。實際呢個問題係好好嘅問題，實係引申到實際我哋諗深一層，法庭嘅工作係最緊要係乜嘢先？第一樣咧，法庭嘅工作最緊要咧就係審理案件，所以咧法庭咧係需要一個安靜嘅環境，去專心嘅處理案件嘅過程，同埋審理案件、聽證據同埋作出判決嘅。第二樣嘢我哋要諗一諗咧，就係點解法庭聆訊要公開？換句話講，點解要有旁聽？旁聽者容許佢嚟參觀呢個法庭程序有咩目的呢？最主要嘅目的呢，旁聽者參加或者法庭嘅聆訊呢，就係要嚟發揮一個監督嘅作用，就係監督法庭呢按住法律、按住咧程序去公平嘅、公正嘅去審案。嗱，我覺得呢兩個原則就好緊要嘅，你揸住佢咧就可以有時咧就處理到好多正話呢位記者朋友去問嘅問題。任何嘢如果阻礙到、妨礙到，或者令到個法官分心，唔能夠專心一意嘅審理案件啦，譬如話聽控辯雙方嘅論據啊、聽證據啊，或者作出判決咧，都係有礙咧法庭佢嘅工作嘅。另外，如果任何旁聽人士佢嚟到嘅 目的佢唔係話為咗監察法庭係根據法律程序公平公正嘅審案，而有第二啲嘅目的，包括去表達佢自己嘅意見啊咁樣樣咧。呢個咧亦都有違反咗咧點解要有公眾參與審訊呢個目的嘅。咁我哋喺呢兩個大原則之下咧，你就睇到咧法庭咧會因應咧各類嘅實際情況，採用各類嘅實際嘅手段去咧保障佢自己能夠咧好專心一意嘅，好唔分心嘅去審案。所以咧睇個情況而定嘅。有時保障自己專心一意審案嘅方法呢，就係發出指示啦，停止一啲滋擾性嘅或者令人分心嘅行為啦，甚至無呢就係要求喺呢啲行為嘅人士離開法庭現場啦，甚至無呢如果嚴重嘅話呢，可能呢構成一個藐視法庭嘅情況嘅。但係有時調翻轉嘅喎，你為咗要專心審案呢，就反而咧就唔可以俾一啲咧一啲嘅動作啊，或者一啲舉止咧嚟分咗佢心嘅。因為如果唔係咧，成日掛住處理呢啲嘅秩序嘅情況嘅時候咧，就會本末倒置咗啦。咁當中嘅拿捏咧，就唔能夠一概而論嘅，就要睇每一單案每一個法官嘅處理嘅。咁希望就答到呢位記者朋友嘅問題啦。
中間藍色衫嗰位男士咧係。
喂，你好啊 ，Now TV 嘅。首先咧就想問下，其實喺過去1年啦，社會上面有好多一啲大型嘅媒體結業啦，亦都有啲民間嘅組織係要解散。咁有啲負責人咧就被控係違反國安法㗎。咁其實法庭喺執行國安法嘅時候，同埋保障社會嘅結社同埋出版自由嘅時候咧，有冇做到一個平衡位呢？第二條問題咧，想問一問，其實過去1年啦，正如張官你所講，一啲針對司法機構嘅一啲恐嚇嘅數字都係有所提升嘅。其實係唔係表示市民對於司法機構嘅信心咧，仍然係未恢復啦？同呢啲嘅恐嚇嘅案件同法庭需要處理國安法有冇關係呢？唔該。
多謝呢位記者朋友嘅問題啦，兩條都係觸及到國安法嘅。國安法呢裏邊呢有係香港嘅法律之一啦，咁又係裏邊呢亦都有明文規定關於保障香港人嘅基本人權嘅條文嘅。你睇國安法第4條同埋第5條呢，裏邊亦都呢有清楚嘅講到嘅。喺法庭審理國安法嘅時候呢，當然要全盤考慮國安法裏邊所有嘅條文，包括呢有關嘅控罪嘅條文啦、程序方面嘅條文啦，同埋呢正話我講到嘅第4條同埋第5條關於市民嘅基本權利啊、程序上嘅公義啊各方面嘅條文嚟處理嘅。咁呢個法庭呢係毫無疑問會根據香港適用嘅法律嚟審理每一單嘅案件嘅。第二個至於話嗰個恐嚇法官嗰個呢，我會咁相信啦。呢啲咁極端嘅行為呢，係極少數嘅人士呢，佢嘅一啲極端嘅做法，可能佢源於對一啲嘅事情不滿。但我想強調咧，呢個唔能夠咧，你係延伸到話咧，普遍人都對法庭嘅表現有啲嘅睇法。呢個我唔同意嘅。我覺得咧，香港係有法治，而普遍咧嚟講咧，公眾嘅對法治嘅信心咧，亦都係好強嘅。
張官你好，香港01嘅，想問3個問題嘅。首先第一樣嘢咧就係你喺你嘅speech 嗰度提到咧，就即係認為即係國安法嘅指定法官佢審理案件咧，就其實同其他法官審理其他案件咧都係別無二致咁啦。咁如果係咁，你認為即係指定法官嘅存在本身有啲咩重要性咧？另外就係即係律政司咧頭先喺發言嘅時候都有提到。佢哋會喺法治教育方面咧，積極教導學生啊、教師有啲關於憲法、基本法同埋國家安全嘅知識。咁提到專業層面上咧，亦都搞過一啲香港國安法嘅法律論壇咁樣。 咁你覺得即係咁樣嘅法治教育係咪全面呢？你認為市民對於法治嘅程度認識去到點樣先叫理想呢？第三呢，就係疫情方面啦，想問下即係過去疫情即係持續咗2年啦。咁我提到見你都有提過，即係會嚟緊有啲遙距聆訊嘅一啲安排咁樣嘅。想問下你即係認為喺有啲咩情況之下需要一個遙距嘅聆訊呢？係咪預期即係本港係會繼續喺防疫措施方面有機會係會關閉法院呢？或者係即係一啲以清零為原理嘅呢啲防疫措施咁樣呢？唔該。
多謝呢位記者朋友嘅問題啦。你問到嗰個國安法嘅指定法官，我都講咗啦，就係正話喺我嘅演講都講咗。當然國安法係同埋佢嘅實施、佢嘅內容，呢個呢，我作為司法機構之首呢，係唔係由我嚟評論嘅？點解我正話講嗰個指定法官呢樣嘢呢？我講得好清楚啦，我係純粹呢，由司法機構嘅角度出發，係想呢令到呢社會大眾呢有信心。無論個國安法呢個安排係點樣，或者我哋以前冇呢個安排嘅時候呢，你一單案件嚟到我哋法庭審訊嘅時候呢，我哋一定會呢公正持平嘅審訊。咁呢啲法官根據國安法嘅規定係必定係指定法官，但係從我哋司法嘅角度、司法機構嘅角度，呢個亦都係我想實際講嘅重點嚟嘅。從司法機構嘅角度嚟講咧，呢個指定法官呢，佢同審理呢啲國安嘅條例嘅案件呢，佢嘅做法同佢審理其他案件呢，完全係一樣。佢亦都係繼續咧會遵守佢會確守咧佢司法誓言裏邊嘅內容嘅。所以呢個就係個國安法指定法官個重點啦。第二樣嘢呢，就係你問到呢嗰個公眾教育關於法治呢方面，咁我覺得教育公眾關於法治呢方面呢，唔會嫌多嘅，只會呢，就覺得呢各人呢，各個持份者實際人都有責嘅，佢責任呢，就係叫呢社會呢更加明白乜嘢叫做法治，更加呢大家呢同心努力呢捍衛法治，叫香港呢繼續保持呢個係一個法治嘅社會，呢個係我哋香港成功嘅基石嚟嘅，係非常之重要嘅。咁當然我哋司法機構，我哋有我哋嘅角色啦，我哋嘅最佳嘅俾公眾嘅法治嘅教育呢，就係我哋喺法庭上審案嘅時候秉行公義，而且我哋啲案件審理呢都係公開進行，我哋判案書呢亦都公開。點解你見啲司法機構或者你見首席法官歷任嘅都成日都講大家一定要睇啲判案書，睇個理由呢？呢個亦都係一個呢，希望大家藉着判案書睇個理由呢，明白法庭判案嘅原因。然後呢，如果你話作出評論，完全可以嘅，但係所有嘅評論呢，就建基你睇咗嘅法庭嘅判案理由。咁呢方面呢，亦都實際係對增加普羅大眾對法治呢個觀念呢，係好有幫助嘅。第三樣呢，就講緊遙距聆訊呢個問題啦。遙距聆訊特別喺我哋而家疫情嘅情況睇下，咁啱而家又係疫情好嚴峻嘅時間呢，係一個好必須嘅一個手段嚟等我哋呢，一方面呢，可以同社會上所有其他持份者一樣啦，努力去呢個對抗疫情啦，防止疫情嘅擴散。但係另外一方面呢，又可以繼續呢，我哋履行我哋司法機構嘅一個重要嘅工作，就係呢秉行公義去審案。咁嘅時候呢，呢個遙距聆訊呢，我哋會按實際嘅情況增加同埋呢更加廣泛嘅應用。亦都解釋到點解我今日講呢話呢，就算喺刑事方面，雖然有而家嘅法例規定要求呢某啲情況之下一定要親身出庭，而呢，所以我哋而家呢就係講緊呢諗緊可唔可以修改法例，容許呢就算喺刑事嘅情況之下呢都可以遙距聆訊，但係大前提呢就係一定要係公開，同埋呢唔影響到個刑事聆訊嘅公平公正性嘅嚇。
唔該，明報記者，張官想問下咧，因為你都提到法庭嘅公正持平唔會因為國安法指定法官呢個安排而影響啦。咁但係我哋都知道，即係本身係有陪審團制度，但係就俾指定法官呢個安排所取代。咁其實可唔可以同大眾清楚啲解釋，即係點解國安法指定法官呢個制度係比起喺香港有咁長遠嘅歷史嘅陪審團制度係有優勝之處呢？即係點解公眾要相信嗰3位指定法官，而唔信任被指為係一個社會道德標準嘅陪審團制度呢？咁第二個問題就係關於嗰個法官行為指引啦。咁我哋見到入邊都有好多對於法官嘅行為嘅規定，包括係冇加入，要避免加入啲政治組織啊，又或者審案要大公無私咁樣。咁張官你所講嗰個更新個行為指引，其實係大概係會加邊啲部分呢？即係因為咩社會形勢同埋原因而修改呢啲行為指引呢？咁至於第3個問題就係關於司法效率方面啦，即係張官都有提到話部分案件嘅候審時間比較長。咁其實有個例子就係民主派35架初選案件，即係有啲被告到而家已經還押咗大概10個月，咁嚟緊先會有第4次嘅提訊日咁樣。咁其實如果喺未審先有咁長期嘅關押，其實係咪司法機構所樂見嘅情況呢？唔該晒。
嗱，好多謝呢位記者朋友幾條問題啦，我嘗試下逐一回答你嚇。第一條都係關於國安法嘅指定法官，但係呢個問題就直接問喺關於喺高等法院原訟法庭裏邊喺國安法第46條裏邊適用嘅情況之下，由3位指定嘅原訟法庭嘅法官審理代替呢個陪審團嘅審理。嗱，我想再強調一次，我作為司法機構嘅之首呢，我唔係喺呢度咧評論國安法嘅內容或者佢嘅運作嘅。我今日提到國安法咧嘅指定法官呢，唯一一個原因呢，就係要想講清楚，根據國安法裏邊嘅指定法官嘅安排嘅底下審嘅案呢，同其他嘅案一樣，係法庭會公正公平嘅去審案嘅。唔會因為有呢個指定法官，又或者呢個第46條裏邊3個指定法官代替一個陪審團去審案呢，有所影響。呢個係我想講嘅重點嚟嘅。我喺呢度呢唔會評論，亦都唔係由我嚟評論呢國安法裏邊嘅各樣嘅安排，包括呢個喺第46條適用嘅情況之下，由3名原訟法庭嘅法官代替陪審團去審案呢一樣嘢嘅。我強調嘅咧就係話咧，根據咁嘅安排底下咧，我哋司法機構角度嚟講咧，我哋嗰3個法官咧會一樣按住佢嘅司法誓言咧，根據法律好公正嚴明嘅去審理案件，而且佢哋嘅判決咧會有一個詳細嘅書面理由，係會咧刊登喺網上，公眾咧可以查閲、參考、閱讀同埋監督嘅。而所有嘅案裏邊嘅程序咧，完全咧同有陪審團嘅案嘅程序一樣。呢個亦都係國安法第4條同埋第5條裏邊嘅規定嚟嘅。萬一一個被告人喺咁嘅審訊情況之下咧，佢被定罪咧，佢上訴嘅途徑咧，同咧唔係喺第46條安排底下嘅有陪審團嘅刑事案件審訊一個被告人被定罪，佢上訴嘅途徑咧係完全一樣，上訴到佢嘅都係喺上訴庭或者去到終審法院，內容嘅係同埋程序咧係完全一樣嘅。嗱，第2條問題呢，就係講嗰個法官行為指引。嗱，喺我嗰個演詞都講咗啦，我哋呢個法官行為指引呢，當年做出嚟嗰陣時咧係一個先驅嚟嘅。我哋可以引以為傲嘅，因為當年嚟講咧，好少地區咧就講呢個法官行為嘅指引嘅。喺2004年呢，我哋作出呢個指引係做得好好嘅，但係時間已經過去啦，一定要與時並進。你要數下2004年到而家已經接近20年啦，冇啦，但係18年啦，都好多日子，好多2004年冇嘅嘢今日都有啦，係咪？大家都睇住個手機啊、Facebook 啊、IG 啊，好多呢啲嘢啦，係咪？咁以前法官唔會用呢啲嘢嘅，譬如話嘅時候，亦都冇呢啲需要處理，但係今時今日咧必須要處理啦。你諗翻2004年嘅當時 嘅案件可能都冇咁複雜啦，或者個社會關注唔係到今日咁樣情況。咁審理呢啲咁多咁複雜嘅案件喺而家傳媒同埋social media 咁多嘅注意之下，法官嘅工作啊，咁嘅點樣做嘢啊，點樣處理呢？更新呢個指引呢係完全有需要嘅。咁更新呢個指引呢，只會加強法官嘅喺佢嘅操守同埋行為方面嘅要求嘅啫，對秉行公正呢係有百利而無一害嘅。呢度呢係第二樣嘢啦。第三樣條題目呢，就係嗰個司法個效率呢個問題啦。特別呢位記者朋友，你提到嗰個47人案啦，但係我就唔會喺度咧評論任何嘅案件嘅。但係我想講幾樣嘢，因為呢個都係一個好嘅題目嚟嘅。你亦都提到個保釋嘅問題。嗱，國安法裏邊嘅保釋嘅條文咧已經寫咗喺度，終審法院咧亦都作咗判決㗎啦。咁呢啲係法例嚟嘅，法庭審案就必定要跟隨嘅。呢個明白嘅。既然咧有保釋係高門檻嘅時候咧，大家期望啲案件可以快啲審，呢個完全明白。而且實際上咧，大家如果有留意咧，國安法自己嘅條文本身第42條本身咧，亦都要求所有嘅有關方面，包括法庭咧，喺呢啲案係盡快審嘅。咁呢個係一個配套嚟嘅，完全明白嘅。但係大家亦都要明白，我哋香港咧係行一個普通法嘅制度嚟嘅，其中一個制度嘅特色咧係我哋嘅程序咧好均真嘅，好認真嘅。要審一個案咧，唔係話我今日想審，聽日就可以開審嘅，唔係咁解嘅。你可以當話可以，我哋係要有好多嘅程序，好多功夫要去準備嘅。咁國安法嘅案件咧，亦都唔例外。當然比較簡單嘅案件呢，可以相對嘅時間係比較少去審理咗。事實上，我哋法庭呢係喺國安法生效之後呢，到而家呢，大約有60幾單嘅國安法嘅案件呢，有好多當中有好多案件呢，我哋都已經審理咗㗎啦。但係一啲被關注嘅案件呢，佢被關注嘅原因，其中一樣嘢就係牽涉眾多嘅人啦，案情複雜啦，眾多嘅律師啦。好多嘅文件啦，有好多嘅可能爭辯嘅地方嘅時候咧，咁無可避免地根據我哋普通法嘅程序係咧有好多嘢咧要做嘅，所以先能夠咧個案件去到一個審訊嘅程序。所以咧就喺呢方面咧，就大家要明白，我哋從司法角度、司法機構角度咧，亦都根據國安法嘅要求咧，已經係盡速嘅去處理各個程序。以期呢個案件呢可以盡快排期審訊，呢方面呢我哋係明白到當中嘅需要嘅。但係呢社會上嘅人士呢亦都要明白審案呢唔係可以一步就成功嘅，亦都要有好多嘅程序要做得到嚇。咁我希望答咗呢位記者朋友問題。
Hello, Justice Zhang. This is from the SCMP. May I just first follow up on one question asked by a fellow? Do you think it's unsatisfactory for many of the defendants involved in national security and seditious crimes to be denied bail for many occasions? How do you respond to criticisms that their basic rights are undermined? Second question is about the foreign judges. Last year, an Australian judge became the first foreign judge to resign from the court, and later, former British judge, also said that he or she will quit CFA. So, do you think their actions reflected their absence of confidence in Hong Kong's judicial independence and the NSL? And the third question is about Article 23. As the Hong Kong government has already announced plans to create the new national security crimes under Article 23, so do you think the new laws would further undermine Hong Kong's freedom and judicial independence, as some critics suggested? Thank you.
Thank you for the 3 questions. I'll try to answer them this way. Now, first, in relation to the national security law cases, I will, of course, not comment on any individual cases. Now, but I would draw attention to several matters. One, in relation to the bail provisions. Now, it is stipulated under the relevant threshold for granting bail or the conditions for refusing bail have been set out very clearly in the provisions of the national security law. And the Court of Final Appeal has already given a definitive ruling on the meaning of the provisions. All courts will have to follow the provisions in considering the question of bail. Now, undeniably, the threshold for granting bail in national security cases is high, and that's why it is in the interest of everybody to get on with the hearing of the cases as soon as possible. In fact, that is not something new. That is envisaged under the national security law itself. Article 42 of the law requires all parties involved, including the courts, to proceed with the hearing of national security cases expeditiously. Now, having said all that, I have to point out also that in Hong Kong we have the common law system, and one key or one characteristic of this common law system is emphasis on procedural safeguards and procedural protection. Now that means in terms of steps and in terms of time required in order for, in terms of steps to be taken and in terms of the time required for a case to reach the trial stage in relation to those matters. Now it is not something like, oh, I want a case to be heard as soon as possible so I can have a hearing date, for example, tomorrow. No, that cannot be done. Many procedural steps need to be completed before a case can reach the court. Now that is the same whether the case is an NSL case or non-NSL case. In particular, where an NSL case involves a number of defendants and parties and lawyers and voluminous documents, we need to go through all the required procedure before the case can reach trial. For example, you need to have disclosure of evidence, exchange of documents, the application for legal aid, assignment of legal aid counsel, the taking of legal advice, the taking of pleas, and the translation of documents, the certification of the translated documents, and all these before the case can reach the trial stage. These are not steps that you can sidestep in order to have a speedy trial for the sake of having a speedy trial. Because after all, you want to have a trial which is procedurally fair. So there are inherent time requirements, as it were, in relation to getting a case ready for trial. So for NSL cases, many of the cases that have come before the court, we have already dealt with them. But for those really more complex cases involving multiple defendants, they take time. Now, turning to the second question, you asked about the overseas MPJs. You said that our former Australian colleague was the first overseas MPJs to resign from the top court. But I want to say this. He remains the only MPJ who has resigned, and he resigned in 2020 after his resignation in 2020. In 2020 itself, as well as in 2021, last year, as well as, in fact, in this month, we continue to have overseas MPJs sitting with us, many of them remotely, but one or two came to Hong Kong. They sat with us on CFA cases. Now, if you want to talk about the overseas MPJs, now, as mentioned by the president of the Law Society in his address just now, he said he counted the figures. Now, he said there were 6 overseas MPJs, including former Chief Justices, including former presidents of the Supreme Court of the UK, who have agreed to have their terms extended during 2021. Now, not only that, last year we have the serving Deputy President of the Supreme Court in the UK, who came to Hong Kong. In fact, he was one of those who came to Hong Kong to take the judicial oath and then to sit with us in 2 cases. So I do not agree that the foreign judges, foreign MPJs, are losing confidence in judicial independence in Hong Kong. If you look at these objective facts, I would say rather the reverse, i.e. that in fact they continue to show support and confidence in the judicial independence in Hong Kong. Now, turning to your last question, which relates to Article 23 of the Basic Law. Now, all I would say is this. Now, Article 23 is there. It is part of the Basic Law. So there is this constitutional requirement on the part of the Hong Kong SAR to enact a national security law. Now, moreover, that is also a requirement under the NSL. So that is the legal requirement. Now, I would not comment on, and it would not be appropriate for me to comment on the content of the proposed new law, the timing of the enactment, or the consultation required before the law is enacted. That is not within my purview. Thank you.
Thank you. Greg Terode of Reuters. I wish to ask about the consultation from the Chief Executive to you concerning national security judges. Are you satisfied with the degree of consultation? And has any of your advice been heeded? And are you satisfied that enough of it is being heeded? Thank you.
Now, thank you for the 2 questions. Now, they concern the designation of judges to hear national security cases. Now, under the provisions of the NSL, the CE may consult the CJ for the designation. And as I said in my address just now, the CJ, the Chief Justice, may also give views to the CE about possible designations where appropriate. Now, as to the details of the consultation, and they form the subject matter of the questions, the 2 questions asked by this reporter. I'm afraid the consultation is done confidentially, and it is not appropriate for me to disclose any details of the consultation, apart from repeating what I've just said, i.e. that the Chief Justice may be consulted, and the Chief Justice may also, of his own, make recommendations and suggestions to the CE about possible designations where appropriate. Thank you.
Hi, Alvin, for Global Legal Post. I have 3 questions. In your speech, firstly, you mentioned about the appointment of judges, whether local or from overseas, must be based and only based on judicial and professional qualities. So far, no overseas MPJ have heard cases related to national security laws. Are there an implicit nationality hurdle, or are there reluctance from these MPJs? Will the overseas MPJ get to hear these cases, and if so, when? My second question concerns with Lord Hodge, which you mentioned earlier. He was in Hong Kong from late November and heard 2 cases both not related to national security laws. Do you have a chance to discuss with him, and does Lord Hodge have any concerns or response on the national security law that may or may not affect that he and Lord Reed's service on the Hong Kong bench? My final question concerns with the remote hearing, which you mentioned. The Law Society has earlier urged the judiciary to maintain the status quo on criminal cases. Judiciary earlier said it's still considering to roll out the measures in phase, which includes both civil and criminal cases. What does that exactly mean? And do you would maintain that remote hearing for criminal cases should go ahead in any way, despite Law Society's concern? And if that's the case, would you pledge that even the default position the default position under the new scheme would be to maintain in-person hearing even during the epidemic, and there will be access from the press and the public? Thank you.
Now, thank you for the three questions. Now, the first question concerns the appointment of or the designation of judges to hear national security cases in the context of our overseas MPJs in the CFA. Now, I can say that if you look at the NSL, and of course that is the law, there is no there's no nationality requirement regarding the judges that are eligible for designation as designated judges at any levels of court. Now, as to the fact that thus far there have not been any overseas MPJs hearing NSL cases. Now, I have to clarify this thing. Now, when you talk about overseas MPJ, you are by definition talking about the Court of Final Appeal. Now, in fact, thus far in the Court of Final Appeal, there has only been one substantive appeal heard concerning national security law, and that was heard in February last year. Now, and apart from that one substantive appeal, there were only 2 leave applications where normally no overseas MPJs would sit in any event. There were only 2 leave applications concerning the NSL. So those are well, that is the context in which you have to understand the answer that I've just given. Now, in relation to Lord Hodge and other UK judges on the CFA bench as overseas MPJs, now, the very fact that Lord Hodge came to Hong Kong and hear cases, and the statements given by the UK Supreme Court about their continued support and participation in the CFA, I believe, speak for themselves. And I am grateful for their continued confidence in the judicial independence in Hong Kong and in the workings and independence of the CFA in particular. Now, these judges have first-hand knowledge of how the system works in Hong Kong. So when you talk about confidence and when you talk about building your confidence based on informed knowledge, these judges, their continued service in Hong Kong is the best evidence, or is one of the best evidence that you can get. Now, as regards remote hearings, particularly in the context of criminal cases, now I note the concern. That's why I said in my address at the opening of the legal year just now, and that's why I repeated my point just now when answering a similar question. That's why I said that the underlying requirement is that there must be no compromise on the due requirements of open justice and fairness. So that is very important. Even if we were to hold sittings remotely, whether in civil cases or in criminal cases, or perhaps in particular in criminal cases, it is of paramount importance to ensure that the defendant in a criminal case has a fair trial, and the trial is taken is held in public. So that's why I said that although we plan to have the legislative amendments introduced to the legislature sometime this year, we'll still need to further consult stakeholders before we could finalize the provisions, bearing in mind the importance of guaranteeing a fair trial. But having said all that, I think everyone would agree that the judiciary, like everyone else in society, has the responsibility to help fight the pandemic in Hong Kong. Thank you.
Hi. 張官你好，我信報㗎。想問翻3個問題啦。第一個咧都係想跟翻初選案嗰個審訊後審嘅過程比較長嘅問題。其實一直都業界都有講啦 ，justice delayed is justice denied。你覺得其實喺而家初選案過咗1年都未開審嘅情況之下，其實呢句嘢係咪啱咧？即係咪套用到喺呢度啦？你其實司法機構有冇討論過有啲咩方法可以加快到嗰個審訊嘅程序嗰個係啦？係因為有啲乜嘢原因係嗰啲嘅措施可能係唔啱用啊，定還是係你哋係冇討論過咧？呢個第一個問題啦。第二個問題就係關於嗰個嘅行為法官行為指引嗰度，其實你講到就話更新嘅指引其實係希望想加強翻對於法官操守行為嗰個要求啦。咁近日其實鴻門宴事件咁，其實都引起咗社會關注到官員去出席宴會或者接受款待嘅一啲嘅規定。其實司法機構有冇去更新咗一啲對於司法人員去接受款待或者係出席呢啲宴會場合嘅一啲嘅要求規定啦，你自己又會唔會你對於自己去出席一啲宴會場合啊，其實有冇啲乜嘢嘅定下咗啲咩標準？有冇去過咧？係啦，第三個就係想問翻，因為近日啦，咁商人冼國林就宣布就參選呢個特首啦。咁佢喺政綱嗰度咧就都提到就話司法同埋檢控就錯漏百出，咁就打擊大眾市民對法治嘅信心。你覺得一個特首候選人去作出呢一個嘅評論，你點樣回應？你有咩睇法咧？覺得係咪合適咧？同埋對於未下一屆嘅特首，其實你覺得你會期望佢點樣可以維持到香港嘅法治咧？係啊，
好嗱，唔該呢位記者嘅3個問題啦。其實第一條咧都係環繞翻國安法嘅案件嘅審理嘅時間問題啦。實際我明白大家都好關心呢個問題嘅，咁但係大家都留意到咧，我實際今晚咧已經中文又講咗一次，英文再講多次㗎啦。咁所以咧講多次都無妨嘅，但係實際個答案都係一樣，係咪啊？就係話咧，國安法有國安法裏邊嘅規定，而且國安法本身咧，亦都係要求咧所有持份者，包括法庭方面咧，要盡速嘅審理案件嘅，呢個係毫無疑問。但係香港係行一個普通法嘅制度嚟嘅，唔係話你一下就要有嘅。特別係啲案件咁複雜嘅時候咧，唔係話一下你話要審訊就有得審訊嘅。有好多程序嘅嘢一定要做晒先得㗎，你唔可以咧走捷徑嘅。譬如話你文件要翻譯，你唔可以話有人要求要翻譯之下，你唔俾佢翻譯啊咁樣，或者咧翻譯咗，如果有人一定話我要certify 所謂咧就係話認證翻譯得啱，你話我唔使啦，到時審先發覺有錯先改啦。咁呢個係唔理想嘅。又有人話我要申請法援，你話唔使申請法援啦，一路打一路申請啦，慢慢咧你講咗做咗嘢先啦。咁呢個聽落去都覺得會唔公道啦，係咪？又或者有啲人話我要問律師，我要想諗究竟我係打啦定係認罪啦，因為呢個同嗰個判刑有影響嘅。如果大家有留心咧，你判刑嗰時候咧會同你個認罪同埋咩時間認罪有影響嘅。咁你唔可以話咁唔使㗎啦，唔使等你㗎啦，我哋審先啦，你到時先知道法律嘅方面嘅意見，你先再決定啦。咁啊已經太遲㗎啦。咁所以呢啲咁嘅程序嚟講咧，唔係話 特登喺度，亦都唔係因為國安法嘅案件就有呢啲程序，係所有嘅刑事案件複雜嘅咧，你一定有呢個程序嘅需要㗎啦。而呢啲程序咧，大部分點解佢存在咧，係要嚟保障個被告人嘅程序方面嘅公義同埋利益嘅。除非咧被告人同意咧，唔可以隨便嘅跳過咗佢嘅。嗱，答翻你嗰句話，公義延遲就就係等於冇咗公義啦。當然明白嘅，呢啲係一個好好聽嘅好 catchy 嘅 phrase 啊，英文嚟講，即係話令人一講就記得嘅。但係呢啲係原則性，我哋個個都好努力嘅，咁樣去盡快嘅去審案嘅。但係我正話已經第3次解釋緊啦。但係有啲嘢咧，唔係話你急就可以做得到嘅。我哋已經係盡我嘅能力之下咧，係快速嘅審案啦。好啦，呢個第一樣嘢啦。第二樣嘢亦都係問翻嗰個司法嗰個操守呢方面啦。我想呢啲已經係第2次答緊呢個題目㗎啦，係需要與時並進啫。司法行為指引嗰方面咧，係實際要嚟咧幫助翻我哋法官喺現今嘅社會，係2022年啦嘅社會嘅時候，作為一個法官審案公眾嘅期待同埋要求，或者對個人嘅操守嘅一啲嘅期待，俾一啲更新嘅指引。喺各方面咧需要更新嘅時候咧，都係會有一個更新嘅指引啦。遲下就會出版㗎啦，呢個新嘅指引。到時咧，各位朋友咧就可以用心嘅睇一睇咧，就知道嘅內容係更新嘅方面嘅啦。就到最後啦，就係嗰個選舉啦。當然好明顯啦，我作為司法機構之首就唔適合，亦都唔會評論特首嘅選舉參選人嘅任何參選人或者佢嘅政綱或者言論㗎啦。嚇，多謝。
我哋剔多2條問題啊。呢位。
Hi, Chief Justice. You repeatedly said that when it comes to more complex cases, such as the national security case involving more than 30 pro-democracy activists, there's often a need for the courts to spend sufficient time to handle those cases before they are put to trial. But would you admit that it would still be undesirable for any defendants to be remanded in custody for nearly a year before the cases can be heard, as some critics suggested? You talked about the importance of procedural justice. So is procedural justice affected in this case when the defendants have to wait a very long period of time before the cases are put in trial? And is there any room for the court to speed up the process in such cases? For example, can the courts require prosecutors to expedite their investigation? And will you also set a bottom line for the defendants' waiting time? Thank you.
Now, thank you for this question. I'm breaking some record now. I'm answering the same question for the 4th time. I don't know whether that has happened before. Now, I've already said that procedural requirements there are, and you can't sidestep them without the agreement of all, particularly without the agreement of defendants. Now, you can imagine, of course, I'm not commenting on any particular case. When a case involves multiple defendants advised by different teams of lawyers with different strategies and with different cases, now getting an agreement from the parties sometimes, now while it may look easy on paper, but may not be that easy in practice. So for example, whether all parties would agree that, well, there's no need for Chinese, for the translation of documents into English, for example, that sort of simple question. You might have thought that it is a simple question and there could be agreement amongst all, but in fact it may not be the case. And when you have voluminous documents and when there's no agreement to dispense with, I'm taking an example, no agreement to dispense with the translation of documents or the certification of the translations, you can imagine the time that has to be spent on translating the documents and certifying the documents. And you can imagine the time that the court proceedings are being held up because of this legal requirement, which in itself is perfectly legitimate. perfectly legitimate, and the requirement itself is there to protect the interests of the defendants who require the translation. Now, I'm just taking this as an example. There are other requirements: discovery of documents, assignment of legal aid counsel, the taking of legal advice. Now, I've just explained it in Chinese. Now, the getting or the obtaining of timely legal advice is an important matter for a defendant for this particular reason, amongst others, i.e. our law on sentencing and our law on giving of discount to a guilty plea is very much dependent on the time or the stage at which the guilty plea is entered. So if the guilty plea is entered at the first available time after the obtaining of legal advice, then a full 1/3 discount will be given. The later the plea is entered, the less weight it will be given in terms of sentencing. So again, you can immediately see that to a defendant who's charged with an offense, and one of the important things that he needs to do, and one of his rights, is to obtain good, proper legal advice based on all the materials to be relied on by the prosecution in order to decide whether he should fight the case or to plead guilty. Now, that is a very important decision on his part, on his or her part, and that cannot be taken lightly, nor can it be taken without proper legal advice. Now, all these take time, and it is not up to the courts to subjectively say that, oh, I want to have the case tried as soon as possible, maybe next week I'll do it. Then the court can do it. No, the court cannot. We are a common law jurisdiction. We have our rules and we have our procedures. All these rules and procedures are there designed to protect the interests of the parties, including, in particular, the interests of the defendants. Thank you.
我哋最後一條問題，理一下。
好，喂，你好，獨立媒體記者。咁見到張官個 speech 入邊都提到司法宣誓嗰樣嘢啦。咁但係而家喺國安法同埋新嘅2021公職條例底下，咁其實對於法官個宣誓有個新嘅要求嘅。咁想問翻司法機構，張官你自己就做咗啦，你起身嘅時候，咁喺特首嘅監誓底下就宣咗誓啦。咁想問下司法機構其他嘅法官，即係依家係咪都已經全部就係按要求宣晒誓咧？即係若果係已經係做咗嘅話，因為之前都冇資料公開，即係做咗嘅話，會唔會有法官就係即係因為拒絕宣誓而離職咧？若果未做嘅話，個時間表係咩？會唔會擔心即係宣誓又引發一個法官嘅離職潮咁樣咧？唔該。
嗱，多謝呢位記者朋友嘅問題啦。你問到嗰個法官宣誓嘅問題啦，我想澄清少少先。法官咧，根據基本法第104條咧，當上任法官嘅時候咧，佢已經要作出一個司法誓言啦。基本法咧就喺1997年開始喺香港生效，所以1997年開始，所有做法官嘅人咧喺上任嘅時候都要作出呢個司法宣誓嘅。就呢個同國安法裏邊嘅或者其他最近嘅法例裏邊嘅要求係冇關係嘅。咁樣而喺個你講嘅最新嘅法例嘅生效之後咧，亦都唔影響到法官嘅問題。法官係唔需要重新宣誓嘅，因為咧法官嘅我哋需要宣嘅誓咧就係104基本法第104條裏邊規定嘅司法誓言嘅宣誓。而你睇個內容咧，實際同譬如話特首啊，或者係立法會議員啦，或者公務員佢嘅宣誓嘅內容咧，基本上都係相若嘅。你可以話咧，我哋法官咧一早已經有呢個宣誓嘅啦。佢嘅內容咧就包括咧擁護香港特別行政區啦，效忠香港特別行政區啦，擁護基本法啊，然後就秉行公義啊，呢啲關於法官嘅特別嘅內容嘅啫。咁就唔存在係再一次宣誓或者有法官唔肯宣誓呢個問題係冇嘅。但係你有時見到呢啲法官佢升咗一個級嘅時候呢，佢再一次咧作出呢個司法宣誓呢，呢個唔係嚴格嚟講唔係一個特別嘅要求，只不過係一個咧有隆重其事一個儀式， 表示咧佢再重新去遵守呢一個佢做法官第一日開始咧已經作出咗嘅宣誓，係咁解嘅啫。
Okay, last question.
Thank you. Good evening, Mr. Chang. 3 questions from AFP. So you just talked extensively about designated judges under NSL, but it has been 1.5 years since the law came to Hong Kong. We haven't known how many designated judges Hong Kong has. So could you please tell us how many designated judges Hong Kong has? Who are they and why were they designated? Second question is, you mentioned that Hong Kong's judicial independence can be found in open court, publicly accessible judgments and reasons. But it is also a matter of fact that Article 41 of NSL provides that some cases can be tried behind closed doors. Yet, the law does not specify who would make the move and what procedures it will take to determine that a case would be tried behind closed door. Could you also tell us here that whose call is that to determine a case should be tried behind closed door and what procedures it would take? Last question. 1 year ago at the very same ceremony, you did not need to state that judicial independence exists in Hong Kong as a fact. But this year, just now, you did. So are you confident that next year, Hong Kong can prove its judicial independence in a more convincing manner so that you don't have to literally declare a fact in front of everyone? Thank you.
No, thank you for the 3 questions. Again, the designated judges. Now, as we have said many times, the responsibility and the power of designation of NSL judges to hear cases vests in the chief executive. It is for her, after consultations that she requires, to make the designations. So it is not for us or for me to answer for her the criteria for designation. Now, as for the numbers and list of the designated judges, now again we respect the chief executive since she is the appointing or designation authority and vested also with the rights to disclose the names and the details of the designated judges. Now, of course, for the purposes of hearing individual cases and in order to demonstrate that we comply with the law, of course, when we are asked, we would answer by saying that a particular judge who has been assigned to do a particular NSL case is a designated judge. Now, in relation to Article 41 of the NSL, now I'm of course not here to discuss about the content or the workings of the NSL. Now, if you remember, that relates to hearing cases in closed door. Now, all I would say as a very general remark, that hearing cases in closed door in exceptional circumstances is nothing new. It's nothing new in Hong Kong. In fact, in Hong Kong, there are proceedings which are heard in chambers, not open to the public for very good reasons. Now, in fact, again, that is not an arrangement unique to Hong Kong. In fact, in many, many common law jurisdictions, and I believe civil law jurisdictions as well, there are similar procedures to cater for special types of cases. And Article 41 of the NSL happens to be one of those cases, so far as we in Hong Kong are concerned. Now, the third question regarding the declaration of the existence of judicial independence in Hong Kong as a fact. Now, if it is a fact, it can be stated, and so I think it is good for public confidence that as head of judiciary, I stated as a fact that there exists judicial independence in Hong Kong, so that people can have confidence in our system and have confidence in Hong Kong as a special administrative region governed by the rule of law, underpinned by an independent judiciary. Thank you.
OK， 多謝各位。咁今日記者會完結啦。
唔該。